I woke up to the sound of a diesel engine growling outside my bedroom window at 6 in the morning, which was never a good sign in rural Sweetwater County, Wyoming. By the time I pulled on my jeans and stumbled outside, a backhoe was already tearing into the culvert that ran under my private access road, the only way in or out of my property. Standing beside the machine with a clipboard and a satisfied expression was Brenda Patterson, president of the Meadowbrook Heights Homeowners Association, wearing a powder blue pantsuit that had no business being on a construction site. "What the hell are you doing?" I shouted over the noise, but Brenda just held up one perfectly manicured finger as if I was interrupting something important. The backhoe operator killed the engine, and in the sudden silence, I could hear water trickling from the creek that ran through my property. That creek was about to become a much bigger problem. "Mr. Irving," Brenda said, pronouncing my last name like it tasted bad, "the HOA has determined that this culvert represents a drainage hazard to the community. We're removing it and installing proper drainage that meets county specifications." "That's my culvert on my private road on my property," I said, trying to keep my voice level. "You can't just tear it out." She smiled the way a shark might smile at a particularly slow seal. "Actually, according to the original development plans from 1987, this drainage easement falls under HOA jurisdiction. We sent you 3 certified letters about this." "I never got any letters." "That's not our problem. We have the return receipts." She gestured to the backhoe operator. "Continue." I stood there watching as they ripped out the culvert that had been channeling Willow Creek under my access road for the past 15 years. The thing was, I had bought this 5-acre parcel specifically because it sat at the highest point of the development with natural drainage that flowed down through my land before continuing onto the 42 residential lots that made up Meadowbrook Heights. My property was technically outside the HOA boundaries, grandfathered in from before the development existed, but that creek ran right through the middle of my land. By noon, they had removed the culvert entirely and dumped 3 loads of fill dirt across the creek bed, creating a makeshift dam on my property. Water was already starting to pool behind it. "You're going to flood my road," I said to Brenda, who was making notes on her clipboard. "The county engineer approved this plan. If you have concerns, take them up with the planning department." She clicked her pen with an air of finality. "Oh, and Lucas, the HOA will be billing you for half the cost of this remediation work. The easement runs through your property, after all." After she left, I walked the length of my property, following the creek bed. The water that used to flow freely under my road was now backing up, and I could see it was going to get worse. What Brenda and her HOA cronies didn't understand, or more likely didn't care about, was that this wasn't just about my access road. The natural drainage on my property fed into a series of catch basins and culverts that I had installed 5 years ago when I did some excavation work. Those culverts controlled the water flow to every single lot in Meadowbrook Heights. I had done the work legally, with permits, because I was tired of spring runoff flooding my barn. The county had been fine with it as long as I maintained proper drainage downstream, which I had. Until today. My phone rang. It was Tom Burkhart, my neighbor from Lot 41, the property that bordered mine on the east side. "Lucas, what the hell's going on? Brenda just told me you're interfering with the HOA's drainage improvements." "Tom, I didn't interfere with anything. I woke up to them tearing out my culvert without permission." "Well, she's calling an emergency meeting tonight at the community center, 7 o'clock. You should probably be there." I showed up at 6:45, walking into the Meadowbrook Heights Community Center with copies of my property deed, survey maps, and the original drainage permits from the county. About 30 residents were already there, most of them looking confused or annoyed. Brenda sat at the head table with 2 other board members, Gerald Hopkins, the treasurer, who always looked like he had just sucked on a lemon, and Patricia Morrison, the secretary, who nodded along with everything Brenda said like a bobblehead on a dashboard. "We'll call this meeting to order," Brenda announced, even though it wasn't 7 yet. "We're here to discuss the drainage easement situation with Mr. Irving's property. As many of you know, we completed essential drainage remediation work this morning that will protect our community from flooding hazards." "You created a flooding hazard," I said from the back of the room. "Mr. Irving, you'll have a chance to speak during the public comment period. Please hold your outbursts." I bit my tongue and waited while Brenda spent 20 minutes explaining how the old culvert was substandard and deteriorating and posed a significant risk to the community. She had photos, charts, and a report from an engineering firm I had never heard of. Now, she said, Mr. Irving does have an easement through his property that affects our drainage patterns. However, the original development agreement clearly states that all drainage easements fall under HOA control for the benefit of the community. That agreement was written before I bought my property, I said, standing up. My parcel isn't part of the HOA. I don't pay dues, I don't vote, and you don't have jurisdiction over my land. The easement predates your ownership. Show me the easement documents. Brenda shuffled through her papers. I don't have them with me, but they're on file with the county. I checked with the county yesterday afternoon. There's no easement registered on my property in favor of the HOA. The only easements are utility easements for power and water. The room got quiet. Gerald leaned over and whispered something to Brenda, who stiffened. Regardless, she said, the work has been completed to county specifications. If you have a legal dispute, you're free to hire an attorney. Here's what I know, I said, walking toward the front with my survey map. That creek you just dammed up on my property is the primary water source for all the drainage on my land. I control where that water goes. For the past 5 years, I've been maintaining a series of culverts and drainage pipes that channel water to your lots. Those pipes prevent your basements from flooding every spring and keep your retention ponds from overflowing. I spread the map on the table in front of her. See these blue lines? That's the drainage system on my property. The water flows from the creek through my culverts and down to your development. Now that you've blocked the creek, the water has nowhere to go except onto my access road and my barn foundation. So here's what's going to happen. Tomorrow morning, I'm going to fix my drainage problem. You can't alter the drainage without HOA approval, Brenda said. You just altered my property without my approval. I'm not asking for permission to fix what you broke. I left the meeting with everyone talking at once. Tom caught up with me in the parking lot. Lucas, what are you planning to do? I'm going to reroute the drainage on my property so my access road doesn't flood. That's going to affect the whole development. Should have thought about that before your HOA president decided to play civil engineer on my land. That night, I couldn't sleep. I kept thinking about the water pooling behind that filled dirt, imagining my access road turning into a lake. Around 3 a.m, I got up and made coffee, then sat at my kitchen table drawing up plans. The solution was actually pretty simple. I'd installed 3 main culverts on my property 5 years ago. The primary one ran from the creek down toward the HOA's lots. The other 2 were overflow channels that I had cut during unusually wet years. If I blocked the primary culvert and redirected the water into a natural gully on the western edge of my property, it would bypass the HOA development entirely and flow into the county drainage ditch along Sweetwater Road. Legally, I was on solid ground. The water was on my property, and I had every right to control drainage on my own land, as long as I wasn't deliberately flooding someone else. The county ditch could easily handle the extra flow. It was designed for it. The next morning, I called Roy's Excavation in Rock Springs. Roy Fisher had done the original work on my property, and he knew every inch of the drainage system. You sure about this? Roy asked when I explained what I wanted. They destroyed my culvert and flooded my access road. I'm fixing my problem. What about the HOA? Not my problem. My property, my drainage. Roy showed up at 10 with his excavator and 2 guys on his crew. We worked all day, installing a new culvert that redirected the creek flow into the western gully. By 6 that evening, water was flowing freely again, completely bypassing the HOA's drainage system. My access road was safe, and I wouldn't have to worry about my barn flooding. What I didn't expect was how fast the HOA would notice. Brenda called me at 7:30 that evening, her voice shaking with rage. What did you do? Fixed my drainage problem. You dammed up my creek, so I rerouted it. You cut off water to our retention ponds. Did I? That's unfortunate. The water level in pond number 2 has dropped 6 inches. Our landscaping is going to die. You're deliberately sabotaging the community. I'm protecting my property. The water on my land is my responsibility. What you do with drainage on your lots is your problem. She hung up on me. 20 minutes later, 3 cars pulled into my driveway. Brenda got out of the first one, followed by Gerald and 4 residents I recognized from the meeting. One of them was Derek Manning, who lived on Lot 12 and fancied himself some kind of tough guy because he drove a lifted pickup truck with truck nuts hanging from the hitch. "You need to change that drainage back right now," Derek said, puffing out his chest. "Get off my property." "We have a right to water access," Brenda said. "You're interfering with established drainage patterns." "You interfered with my property first. You want to fix this? Reinstall my culvert exactly as it was, pay for the damage to my road, and maybe I'll consider adjusting the drainage on my land." "We're not negotiating with you," Gerald said, speaking for the first time. "We'll get a court order." "Go ahead. While you're at it, I'll file a lawsuit for trespassing, destruction of property, and any flood damage to my barn or road. I've got photos of your backhoe tearing out my culvert without permission." They left, but I knew this wasn't over. I called my attorney, Martin Shepard, first thing the next morning. Martin had handled the closing when I bought the property, and he was familiar with the local property laws. "They really just tore out your culvert?" Martin asked, sounding incredulous. "At 6 in the morning. Claimed they had easement rights, but I checked with the county. There's no recorded easement." "And now you've redirected the drainage?" "On my property, legally, with the same permits I've always had." Martin was quiet for a moment. "Okay, here's what we're going to do. I'll file a complaint with the county about the unauthorized work on your property. We'll also send a cease and desist letter to the HOA demanding they restore your culvert and pay damages. In the meantime, document everything: photos, videos, any correspondence. They're threatening to get a court order forcing me to restore their water access. Let them try. Water rights in Wyoming are complicated, but you're not obligated to provide drainage for their development, especially after they damaged your property. They'd have to prove an established easement or show that you're deliberately causing harm." "I'm not causing harm. I'm preventing harm to my property." "Exactly. Keep it that way." 3 days later, I got served with papers. The HOA was seeking a temporary restraining order to force me to restore the original drainage pattern. The hearing was set for the following week at the Sweetwater County Courthouse in Green River. I spent those days gathering evidence. I took probably 200 photos of the pooled water on my property, the damaged road surface, and the fill dirt the HOA had dumped across the creek bed. I dug up the original drainage plans I had submitted to the county 5 years ago, showing that my culverts were always meant to be adjustable based on water flow needs. I even got a written statement from Roy Fisher explaining the work we had done and confirming it met all county specifications. The day before the hearing, Brenda showed up at my property alone. She looked different, less put together than usual. Her hair was pulled back in a messy ponytail, and she wasn't wearing any makeup. "Can we talk?" she asked. "About what?" "Look, maybe we got off on the wrong foot. The board really thought we were doing the right thing with that culvert. The engineering report said it was failing." "Which engineering company?" "Pinnacle Engineering Solutions." "Never heard of them. Are they local?" "They're based in Cheyenne. Gerald found them." "That was interesting. Did they actually inspect the culvert or just write a report based on photos?" Brenda hesitated. "I'm not sure. Gerald handled that part." "So Gerald hired an engineering firm from 3 hours away to justify tearing out a perfectly functional culvert on property the HOA doesn't own, and you went along with it?" "He said we had easement rights." "Did you verify that?" She didn't answer, which was answer enough. "Here's the thing, Brenda. I don't care if this was incompetence or malice. You destroyed my property, and now you're dealing with the consequences. If you want your water back, reinstall my culvert properly, pay for all damages, and put in writing that the HOA has no jurisdiction over my land." "We can't afford that. The engineering report cost $12,000. The excavation work was another $8,000. We'd have to do a special assessment on all the homeowners." "You should have thought about that before you started digging." She left, and I almost felt bad. Almost. But the next morning at the courthouse, any sympathy I might have had evaporated when I saw the HOA's attorney. They had hired Dennis Wright, a lawyer from Casper with a reputation for scorched earth litigation tactics. This wasn't going to be a simple hearing. The courtroom was smaller than I expected, with just the judge, a court reporter, and bench seating for maybe 20 people. Most of the HOA board was there, along with a handful of residents. Martin sat beside me at the defendant's table, looking calm and professional in his gray suit. Judge Catherine Walsh took the bench at 9 sharp. She was in her 50s, with steel gray hair and a no-nonsense expression that suggested she didn't have patience for theatrics. "We're here on an emergency petition for a temporary restraining order," she said. "Mr. Wright, you're representing the petitioner." Dennis Wright stood up. He was a big man, over 6 feet, with the kind of voice that filled a room. "Yes, Your Honor. The Meadowbrook Heights Homeowners Association is seeking immediate relief to restore critical drainage to 42 residential properties. The defendant, Lucas Irving, has deliberately cut off water access in retaliation for legitimate maintenance work performed by the association." "Your Honor," Martin said, standing, "the characterization of events is completely inaccurate. Mr. Irving is the victim here, not the perpetrator." "I'll hear from the petitioner first," Judge Walsh said. "Mr. Wright, present your case." Wright spent the next 20 minutes painting me as a vindictive neighbor who was endangering the entire community out of spite. He had maps, photos of the HOA's retention ponds with low water levels, and testimony from a landscaping contractor who claimed the grass in the common areas was already turning brown. He made it sound like I had committed some kind of eco-terrorism. "The defendant controls critical drainage for the entire development," Wright argued. "His actions are causing immediate and irreparable harm. We're asking the court to order him to restore the water flow while the underlying property dispute is resolved." "Mr. Shepard," Judge Walsh looked at Martin. Martin stood and laid out our case calmly and methodically. He presented the photos of the HOA's backhoe tearing out my culvert, the survey map showing my property boundaries, and the county records showing no registered easement in favor of the HOA. "Your Honor, Mr. Irving woke up one morning to find the HOA destroying his property without notice, without permission, and without legal authority. They dammed up a creek on his land, which began flooding his only access road and threatened his barn foundation. He did exactly what any reasonable property owner would do. He fixed the drainage problem on his own land." "But in doing so, he cut off water to the HOA," Wright interjected. "He redirected water on his own property," Martin corrected. "There is no legal obligation for Mr. Irving to provide drainage for the HOA development. They don't have an easement, they don't have prescriptive rights, and they certainly don't have the authority to destroy his property to create their own drainage solutions." Judge Walsh studied the documents in front of her. "Mr. Wright, you're claiming there's an easement on Mr. Irving's property?" "The original development plans from 1987 reference a drainage easement through the parcel that became Mr. Irving's property." "Do you have that easement document?" "We're still searching the county records, Your Honor. The original developer went out of business in the early 90s, and some of the paperwork wasn't properly filed." "So you don't have an easement document?" Wright shifted his weight. "Not yet, but the drainage pattern has been established for decades." "Mr. Irving has owned the property for 15 years, Martin said. "During that time, he's maintained his own drainage system with proper county permits. The HOA has never claimed easement rights until now, and their sudden assertion of authority conveniently coincides with unauthorized destruction of Mr. Irving's property." Judge Walsh leaned back in her chair. "This sounds like it's going to require a full trial to sort out, but the immediate question is whether to grant the temporary restraining order. Mr. Wright, what evidence do you have that Mr. Irving deliberately caused harm to the HOA?" "He redirected the water immediately after we performed maintenance on the culvert." "After you destroyed his culvert," Martin said, "he was mitigating damage to his own property." "The timing is suspicious." "The timing is cause and effect," Martin replied. "The HOA's actions directly caused flooding on Mr. Irving's property. His response was to protect his land." Judge Walsh held up a hand. "Gentlemen, I've heard enough. Here's my ruling. The petition for a temporary restraining order is denied. Mr. Irving has a fundamental right to control drainage on his own property, especially in response to damage caused by the petitioner. However, I'm also not convinced that Mr. Irving has an absolute right to completely cut off water flow that has been established for decades. This needs to be resolved in a full trial where both sides can present complete evidence about easements, property rights, and damages. She looked at both attorneys. I'm setting a trial date for 8 weeks from today. In the meantime, Mr. Irving, you are not required to restore the previous drainage pattern, but you are prohibited from taking any additional actions that would further alter the water flow. HOA, you are prohibited from entering Mr. Irving's property or taking any action affecting his culvert or drainage systems. Both parties should be prepared to present complete evidence about the history of these properties and the legal basis for your respective claims. The gavel came down, and just like that, we were heading to trial. Outside the courthouse, Brenda intercepted me before I could reach my truck. She looked furious. "You're killing our landscaping," she said. "The retention ponds are drying up. The grass is dying. Property values are going to plummet. You should have thought about that before you destroyed my culvert." We were following the engineering report from a company Gerald hired without verifying anything. Maybe you should be asking him some questions instead of harassing me. I drove back to Sweetwater County thinking about what Judge Walsh had said, the established drainage pattern. That was going to be the HOA's argument, that my property had provided drainage for so long that they had acquired some kind of prescriptive right to it. But prescriptive easements required open, notorious, continuous use for 10 years without the owner's permission. I had actively maintained and modified the drainage system the whole time I owned the property. That should defeat any prescriptive claim. When I got home, there was a message on my phone from Tom Burkhart. "Lucas, call me back. Something weird is going on with Gerald." I called him back. Tom answered on the first ring. "What's up?" "I was talking to Dave Chen, from Lot 17. He's on the Architectural Review Committee. Anyway, he mentioned that Gerald pushed really hard for that drainage project. Like, really hard. Brought it up at 3 straight board meetings, kept talking about liability and flooding risks. But here's the thing. Gerald's lot is the only one in the development that sits high enough that it would never flood, even if all the retention ponds overflowed. So why would he care? That's what Dave wondered, so he did some digging. Turns out Gerald owns 2 lots. His house is on lot 33, but he also owns lot 15, which is vacant. He's had it on the market for 2 years, can't sell it. Because of drainage problems? The lot has some standing water issues in the spring. It's at the lowest point of the development. If the drainage improved, the lot would be worth a lot more. I thought about that. So Gerald manufactured a drainage crisis to justify rerouting water flow, which would have improved his vacant lot and made it easier to sell. That's what it looks like, and he spent $20,000 of HOA money to do it. $20,000 that now has to come from somewhere. Special assessment, $250 per household. People are pissed. This was getting more interesting by the minute. "Tom, can you get me copies of the board meeting minutes where Gerald proposed the drainage project? And any financial records showing how the engineering and excavation work was approved?" "I can try. I know Patricia keeps copies of everything." "Be careful. If Gerald realizes people are asking questions, he might try to cover his tracks." 2 days later, Tom showed up at my property with a manila folder. "Patricia made copies for me. She's getting suspicious of Gerald, too. Some of the numbers aren't adding up." I opened the folder and started reading. The first mention of the drainage project was from a board meeting 9 months ago. Gerald had presented a drainage assessment claiming that the development was at risk of flooding due to deteriorating infrastructure on adjacent properties. The minutes didn't specify what infrastructure or which properties. 3 months later, Gerald brought up the drainage project again, this time with a quote from Pinnacle Engineering Solutions for a $12,000 engineering study. The board approved it with minimal discussion. Brenda and Patricia both voted yes. The engineering report was dated 6 weeks after that. It was 20 pages of technical jargon that basically said the culvert on my property was old and potentially unsafe, and recommended replacing it with a modern drainage system that would optimize water flow throughout the development. The report included a proposal for $8,000 in excavation work. The board approved the full project at their next meeting. According to the minutes, Gerald said he had confirmed easement rights and the work could proceed immediately. "He never confirmed anything," I said, looking at Tom. "There's no easement document because it doesn't exist." "So he lied to the board." Or he was mistaken. Either way, he spent $20,000 of HOA money on a project that benefited his vacant lot and had no legal authority to proceed. Tom whistled. That's going to be a problem. For Gerald, yeah. For me, it's ammunition. I gave copies of everything to Martin, who got very interested very quickly. This changes things, he said when we met at his office in Rock Springs. If we can show that Gerald had a personal financial motive for the drainage project and that he misrepresented the legal authority to proceed, this becomes a case of HOA board misconduct. We might be able to get the whole project thrown out as unauthorized. What about the trial? We still go to trial on the drainage issues, but this gives us a much stronger position. We can argue that the HOA never had legitimate grounds to touch your property in the first place. The next 6 weeks were busy. Martin took depositions from Brenda, Gerald, and Patricia. I spent time documenting the ongoing damage to my property, the condition of my access road, and the water levels in my drainage system. Roy Fisher provided a detailed report on the work we had done and confirmed that everything met county standards. Meanwhile, the HOA was falling apart. Residents started demanding answers about the special assessment. Several people threatened to recall the entire board. Gerald stopped attending meetings. Brenda tried to hold everything together, but she was in over her head. 3 weeks before trial, Martin called me with news. Gerald's selling his house, just listed it yesterday. Both lots, actually. He's asking $420,000 for the house and $95,000 for the vacant lot. He's trying to cash out before everything blows up. Looks that way. I also got the deposition transcripts back. Gerald admitted under oath that he never actually verified the easement. He assumed it existed based on the engineering report. And the engineering company? They did a desktop review using satellite imagery and county records. No one ever physically inspected your culvert. They just wrote what Gerald paid them to write. That's fraud. It's close. Probably not criminal, but definitely grounds for a civil lawsuit. The HOA could sue Gerald and the engineering company to recover their costs. Will they? If they're smart. But first we have to win this trial. The trial started on a Tuesday morning in mid-August. The courtroom was packed with HOA residents, all of them watching to see how this would play out. Judge Walsh took the bench and reminded everyone that this was a property dispute, not a criminal trial, and she expected professional behavior from everyone involved. Dennis Wright went first, calling Brenda as his first witness. She testified about the HOA's concerns about flooding, the engineering report, and the decision to remove the culvert. Martin cross-examined her thoroughly, getting her to admit that she never personally verified the easement, never consulted with me before starting work, and never considered the impact on my property. Did Mr. Irving ever refuse to maintain the drainage system? Martin asked. No, Brenda admitted. Did the HOA ever have problems with water flow before you removed the culvert? Not that I'm aware of. So the drainage system was working fine until you tore it out? The engineering report said it was deteriorating. But you never saw any evidence of that yourself? No, Wright called Gerald next. That's when things got interesting. Martin questioned him about his vacant lot, his financial interest in improving drainage, and his failure to verify the easement. Mr. Hopkins, how much would your vacant lot increase in value if the drainage problems were resolved? I don't know, Gerald said, not making eye contact. You testified in your deposition that the lot was worth approximately $70,000 with the drainage issues and potentially $90,000 to $100,000 with improved drainage. Was that testimony accurate? I suppose. So you stood to gain $20,000 to $30,000 if this project succeeded? That wasn't the reason for the project. But it was a benefit to you personally? Gerald shifted in his seat. It would have benefited the whole community. Except for Mr. Irving, whose property you flooded. That wasn't intentional. Martin pulled out the engineering report. This report recommends redirecting water flow in a way that would specifically improve drainage for lots in the lower section of the development. Correct? Yes. Lots including your vacant lot number 15, among others. And you hired the engineering firm that wrote this report? Yes. Did you tell the other board members that you owned a vacant lot that would directly benefit from this project? Gerald hesitated. It wasn't relevant. You don't think a personal financial interest of $20,000 to $30,000 was relevant to the board's decision? I was acting in the community's best interest. Judge Walsh intervened. Mr. Hopkins, please answer the question. Did you disclose your financial interest to the board? No, Your Honor. The courtroom buzzed with whispers. Wright looked like he wanted to crawl under the table. Martin had just established that Gerald had a conflict of interest that he failed to disclose, which undermined the entire legal basis for the HOA's actions. Wright tried to recover on redirect, but the damage was done. The rest of his case focused on the supposed benefits of the new drainage plan and expert testimony about water flow and retention pond levels. None of it addressed the fundamental question of whether the HOA had the legal authority to tear out my culvert in the first place. When it was our turn, Martin called me to the stand first. I testified about finding the backhoe on my property, the destruction of my culvert, and the flooding damage to my access road. I explained the drainage system I had installed 5 years ago and how I had maintained it properly with county permits. Did you ever deny the HOA access to water? Martin asked. No. Water flowed through my property to their development for 15 years without any problems. What changed? They destroyed my culvert and created a dam on my land. I had to reroute the water to prevent my road from washing out. Did you have any intention of harming the HOA? None. I was protecting my property from damage they caused. Wright's cross-examination tried to paint me as vindictive and unreasonable, but I kept my answers simple and factual. Yes, I knew the HOA would lose water when I rerouted the drainage. Yes, I could have tried to negotiate a solution. But no, I wasn't obligated to let my property flood while the HOA figured out that they had screwed up. Martin called Roy Fisher next, who testified about the drainage work we had done and confirmed that everything was properly permitted and met all county specifications. He also testified that the original culvert the HOA had removed was in good condition and didn't need to be replaced. Bishu, in your professional opinion, was there any legitimate engineering reason to remove that culvert? No, Roy said firmly. It was functioning properly and had at least another 20 years of life left in it. Our final witness was a county engineer named Sarah Drummond, who had reviewed all the drainage plans and permits for both my property and the HOA development. She testified that my property had no recorded easements in favor of the HOA, and that I had every legal right to control drainage on my own land as long as I wasn't deliberately flooding someone else. Is Mr. Irving deliberately flooding the HOA properties? Martin asked. No, he redirected water on his property to a county drainage ditch. That's a perfectly appropriate use of the county drainage system. The HOA lots are not flooding. They're just not receiving the water they used to receive, which they never had a legal right to in the first place. Wright tried to argue prescriptive easement on closing, claiming that 15 years of established drainage created an implied right for the HOA. Martin countered that prescriptive easements require adverse use without permission, and I had actively maintained and modified the drainage system throughout my ownership, which proved the HOA's use was permissive and could be revoked at any time. Judge Walsh took 2 days to issue her ruling. When we reconvened on Thursday afternoon, the courtroom was even more packed than before. I've reviewed all the evidence and testimony, Judge Walsh began. This case raises important questions about property rights, easements, and the authority of homeowners associations. Let me address each issue in turn. She put on her reading glasses and looked at her notes. First, the question of easements. The HOA has failed to produce any recorded easement granting them drainage rights across Mr. Irving's property. They've also failed to establish a prescriptive easement, as the evidence shows Mr. Irving actively maintained and modified the drainage system throughout his ownership, which is inconsistent with adverse use. Therefore, I find that the HOA has no easement rights on Mr. Irving's property. Dennis Wright's shoulders slumped. Brenda looked like she might cry. Second, the question of authority. The HOA argues that they had the right to remove the culvert based on the engineering report and their interpretation of the development agreement. However, the evidence shows that no one verified whether the HOA actually had jurisdiction over Mr. Irving's property before beginning work. This was a fundamental failure of due diligence. You cannot claim authority over property that isn't subject to your jurisdiction. Judge Walsh looked directly at the HOA board members. Furthermore, the evidence suggests that this project was initiated based on a conflict of interest that was not disclosed to the board or the membership. Mr. Hopkins stood to benefit financially from the drainage improvements, yet failed to inform the other board members of this interest. This raises serious questions about the legitimacy of the entire project. She continued. Third, the question of Mr. Irving's response. The HOA argues that Mr. Irving acted unreasonably by rerouting the drainage and cutting off water to their development. However, the evidence shows that Mr. Irving was responding to immediate damage to his property caused by the HOA's unauthorized actions. He had every right to protect his land, and he did so in a legal manner using proper permits and county-approved drainage channels. Therefore, I find in favor of the defendant, Lucas Irving, on all counts. The HOA is ordered to remove the fill dirt and debris they placed on Mr. Irving's property and to restore the culvert to its original condition at their expense. They are also ordered to pay Mr. Irving's legal fees and any documented damages to his property, including road repairs and any other costs incurred as a result of their actions. The gavel came down. I had won. Outside the courthouse, reporters from the Rock Springs Rocket Miner and the Sweetwater County Gazette wanted interviews. I kept it brief, saying I was glad justice had been served, and I looked forward to having my property restored. Brenda walked past without making eye contact. Gerald was already gone, having left during the lunch break. Tom Burkhart congratulated me and said the HOA was going to have an emergency meeting to figure out how to pay for everything. How much is this going to cost them? Tom asked. Restoring the culvert, maybe $10,000. My legal fees are around $30,000. Road repairs, another $5,000. They're looking at close to $50,000 total, plus they already spent $20,000 on the project. That's $70,000 out of pocket. We're going to have to do a massive special assessment. People are going to lose their minds. Maybe they should have been paying closer attention to what their board was doing. 3 days later, the Meadowbrook Heights HOA held an emergency meeting. I didn't attend, but Tom gave me the details afterward. The meeting turned into a shouting match. Residents demanded to know how this had happened, who was responsible, and how they were supposed to pay for it all. Brenda tried to explain about the engineering report and the easement confusion, but no one wanted to hear it. Patricia read a financial report showing that the HOA only had $30,000 in reserves, which meant they would need to assess each of the 42 households approximately $950 to cover the remaining costs. People went ballistic, Tom told me. Derek Manning called for the entire board to resign. About 20 other people agreed. Brenda started crying and walked out. What about Gerald? He didn't show up. Someone said he's already moved out, listed both properties with a realtor in Rock Springs and left town. Running from his mess. Looks like it. The board is talking about suing him to recover the costs. They should. He created this whole disaster. The next week, Roy Fisher's crew showed up to start removing the fill dirt from my creek bed. It took 3 days to clear everything out, and another 2 days to install a new culvert identical to the one they had removed. The HOA paid for all of it, though I could tell they were furious about every dollar. When the work was done, I inspected everything carefully to make sure it was correct. The culvert was properly installed, the creek was flowing freely, and my access road was no longer in danger of flooding. I tested the water flow during a heavy rainstorm, and everything worked perfectly. With my culvert restored, I now had a decision to make about the drainage on my property. Judge Walsh's ruling didn't require me to restore water flow to the HOA, only to allow them to fix what they had broken. The question was whether I wanted to be vindictive or practical. I called Martin to discuss it. What happens if I keep the drainage redirected to the county ditch? You're legally allowed to. The court established that you have no obligation to provide drainage for the HOA. But you'd be making permanent enemies of all your neighbors, and there's always a chance they could try to establish prescriptive rights again in another 10 years if you redirect it back now. So I'm damned either way. Not exactly. Here's what I'd suggest. Restore the drainage to its original configuration, but record a formal drainage agreement with the county that explicitly states the HOA has permissive use only, which can be revoked if they interfere with your property again. That way, you're being a good neighbor, but you're protecting your legal rights. It made sense. I had never wanted to cut off the HOA's water in the first place. I just wanted them to leave my property alone. I called Roy and asked him to redirect the drainage back through my primary culvert system the way it had been for 15 years. It took one day and cost me $1,200, which I considered a worthwhile investment in neighborhood peace. The water started flowing to the HOA lots again on a Saturday morning. By Saturday afternoon, I noticed the water levels in the retention ponds rising. By Sunday, everything looked normal again. Tom called me that evening. "People are noticing the water's back." "Good. Why'd you do it? You didn't have to." "Because I'm not trying to destroy the HOA. I just wanted them to leave me alone." "Well, some people appreciate it. There's talk of recalling the whole board and starting over with people who actually know what they're doing. That would be a good start." 2 weeks later, I got a certified letter from a law firm in Casper that I didn't recognize. Inside was a notice that the Meadowbrook Heights HOA was suing Gerald Hopkins and Pinnacle Engineering Solutions to recover all costs associated with the drainage project. They were alleging breach of fiduciary duty, conflict of interest, negligence, and professional malpractice. Good for them, I thought. Gerald had created this disaster through his greed and incompetence. He should pay for it. Martin called me with an update a few days later. The HOA's lawsuit is moving forward. They've also filed a complaint with the State Engineering Board about Pinnacle Engineering. Apparently, the engineer who signed off on that report never actually visited the site or inspected the culvert. Is that illegal? It's a violation of professional standards. The engineer could lose his license. What about Gerald? He's trying to sell his properties quickly and leave the state. But the lawsuit put a lien on both lots, so he can't close on any sale until the case is resolved. So he's stuck. Completely. And it gets better. The HOA filed a criminal complaint with the county attorney's office about the misappropriation of HOA funds. They're arguing that Gerald used his position on the board to spend $20,000 on a project that primarily benefited him personally without disclosing his conflict of interest. Is that actually criminal? It could be, depending on how the county attorney interprets it. At minimum, it's civil fraud. At maximum, it could be theft or embezzlement. I hadn't expected that. So Gerald could face criminal charges? Possibly. The county attorney is investigating. 3 months later, I was working in my barn when a sheriff's deputy pulled into my driveway. For a second, I thought I was in trouble for something, but the deputy just wanted to let me know that Gerald Hopkins had been arrested that morning on charges of theft and fraud related to the HOA drainage project. "Was? We're notifying people who were affected by his actions," the deputy said. "The county attorney might want you to testify at the trial." "What's he charged with specifically?" "Theft by deception and misuse of corporate funds. Basically, he lied to the HOA board about the drainage project to benefit himself financially, and he used HOA money to do it. That's a felony if the amount is over $5,000, which it was." Good. He should face consequences. Gerald's trial was set for the following spring. In the meantime, the HOA underwent a complete transformation. Brenda, Patricia, and the other board members all resigned. A new board was elected, including Tom Burkhardt as president. They hired a professional management company to handle the finances and brought in a real attorney to review all the HOA's policies and procedures. Tom reached out to me about a month after taking over as president. "I want to make this right between you and the HOA. The court already handled it." "I know, but there's bad feelings on both sides. I'd like to work out a formal agreement about the drainage so everyone knows where they stand." We met at his house the following week. Tom had consulted with the HOA's new attorney, and they had drafted a drainage agreement that acknowledged my ownership of the land and my right to control water flow, while also documenting that I was allowing water to flow through my culverts to benefit the HOA properties as a courtesy, not an obligation. This protects both of us, Tom explained. You maintain full control of your property, and we're on record acknowledging that. If we ever need to do maintenance or improvements to the drainage system, we have to get your written permission first. What about the HOA paying me for the easement? We discussed that. The board authorized a one-time payment of $5,000 in recognition of your cooperation and to compensate you for the hassle of the past year. I thought about it. $5,000 was reasonable, and the agreement gave me everything I needed. Okay, I can live with that. We signed the agreement, and I recorded it with the county the next day. For the first time in a year, I felt like the whole mess was actually resolved. Gerald's trial happened in April. I testified about finding the backhoe on my property and the subsequent flooding of my access road. The prosecution presented evidence about Gerald's conflict of interest, his failure to disclose his ownership of the vacant lot, and his misrepresentation to the board about the easement rights. The defense argued that Gerald had made an honest mistake and had genuinely believed he was acting in the HOA's best interest. But the jury didn't buy it. They found him guilty on both counts of theft by deception and misuse of corporate funds. The judge sentenced Gerald to 3 years in prison, suspended to 1 year with the rest on probation, and ordered him to pay full restitution to the HOA for all costs associated with the drainage project, including my legal fees and damages. That came to around $75,000 total. He'll probably never pay it all, Martin told me after the sentencing, but at least he's got a criminal record and he'll be on probation for years. That's something. It was more than something. It was justice. By summer, things had settled into a new normal. My drainage system worked perfectly, the HOA left me alone, and Gerald's vacant lot sat on the market with a lien attached that scared away every potential buyer. Eventually, the HOA's civil lawsuit concluded with a settlement where Gerald agreed to sign over the vacant lot to the HOA in partial satisfaction of the judgment. They sold it to a young couple from Rock Springs for $85,000 and used the money to replenish their reserves. Brenda moved away, apparently too embarrassed to stay in the community after everything that happened. Patricia stayed but kept a low profile. The new board, under Tom's leadership, ran things professionally and transparently. They actually consulted with homeowners before making major decisions, which was a novel concept. I ran into Tom at the hardware store in Rock Springs one Saturday morning, about a year after the whole thing started. "How's the HOA treating you?" I asked. "Good. We've got our finances straightened out and people are actually happy with how things are running. No more surprises." "That's good to hear. You know, I wanted to thank you." "For what?" "For not being as vindictive as you could have been. You had every right to keep that water redirected and make all our lives miserable. Instead, you worked with us and gave us a chance to make things right." I thought about that morning a year ago when I had woken up to the sound of a backhoe tearing out my culvert. I thought about the stress, the legal fees, the uncertainty of not knowing how it would all turn out. But I also thought about the alternative, where I spent the rest of my time on this property at war with my neighbors, always looking over my shoulder, always waiting for the next conflict. "I just wanted to be left alone to live my life," I said. "I didn't want to destroy the HOA. I just wanted them to respect my property." "Well, we do now. Lesson learned." We shook hands, and I drove home to my 5 acres at the top of the hill, where Willow Creek flowed peacefully through my land just like it had for generations, carrying water down to the valley where 42 families lived their lives, blissfully unaware now of the complex drainage system that kept their basements dry and their retention ponds full. Some people never learn that being a good neighbor is a two-way street. It requires respect for property, respect for boundaries, and respect for the fact that actions have consequences. Gerald learned that lesson the hard way, with a criminal conviction and financial ruin. Brenda learned it with public embarrassment and having to leave the community she had tried to control. As for me, I learned that standing up for your rights sometimes means going to war, but winning doesn't mean you have to burn everything down. Sometimes the best victory is the one where everyone walks away a little wiser, a little more careful, and a lot more respectful of the lines that separate my property from yours. I pulled into my driveway and looked at the access road where the culvert now sat, properly installed and functioning exactly as it should. Water flowed beneath it, clear and cold from the creek, continuing its ancient journey down the hillside. Nature didn't care about property lines or HOA meetings or legal battles. It just flowed where gravity took it. But humans cared. We built our little empires and defended our territories and sometimes forgot that we're all just temporary stewards of land that was here long before us and would be here long after we're gone. The key was to be a good steward, to respect the land and the people around you, and to remember that power, whether it comes from owning property or sitting on an HOA board, carries responsibility. Gerald forgot that. Brenda forgot that. But Tom and the new board seemed to understand it, and that made all the difference. I walked into my house, made coffee, and sat on my back porch watching the sunset over the valley. The sound of running water from Willow Creek was peaceful, almost meditative. Everything was as it should be. Everything was right. And if anyone ever tried to tear out my culvert again, well, I knew exactly what to do.